I'm Tom Merritt for Tech Republic. Here are 5 things to know about EU-US data privacy. If your company holds data on people in both Europe and the United States, you have to follow the privacy laws of both countries. That gets tricky if you move data from European users into the US, which has different laws. So, how do you make sure you're following the rules and keeping data safe? The answer has changed several times in the past few years. There are 5 things to know about EU-US data privacy. Number 1, either the NSA, Edward Snowden, or both get the blame for making this complicated. From 2000 to 2015, an agreement called Safe Harbor covered the transfer of data between the EU and US. But when Snowden's leaks showed that the NSA was accessing bulk collected data, Max Schrems brought a lawsuit, and the Court of Justice of the European Union ruled that Safe Harbor rules were insufficient. Coming in at number 2, Privacy Shield. A second attempt to create a framework was created in 2016. Under Privacy Shield, the US made clear that its NSA could only access bulk data in 6 specific cases. The US also created an ombudsperson and other avenues for Europeans to file complaints about data use. Up to number 3, Max Schrems led a case against this Privacy Shield as well, which was declared illegal by the Court of Justice of the European Union in June 2020. Despite the new restrictions and the addition of complaint handling, the court said the limitations on the protection of personal data are not circumscribed in a way that satisfies requirements that are essentially equivalent to those required under EU law. Sliding in at number 4, the fallback options. There are still options to justify data transfer called standard contract clauses and binding corporate rules. Each company has to enact these on their own, and standard text for these is created by the EU, but a company needs a little more expertise to implement them. They were not declared illegal by the court. At number 5, however, the court did say it was up to companies to make sure that SCCs and BCRs, or whatever they use, provide adequate protection. A new group, led by Max Schrems, filed complaints against 101 European websites, arguing that the US doesn't provide adequate protection for Europeans against surveillance. And subsequently, Ireland's Data Protection Commissioner issued a preliminary rule that Facebook's SCC is not sufficient. Good news! The EU is working on revisions to the SCC to make it stand up to challenges better. The US and EU are also working on a new overarching framework. The other option is to keep all your EU data in the EU, but that's costly and not practical for all companies. In fact, Facebook even intimated it might not be able to operate Instagram and Facebook in Europe if it wasn't able to use SCCs. But hey, there's more where that came from. Check out our other videos and articles at techrepublic.com. I'll see you there.